Good morning, ladies and gentlemen of the court, justices, and opposing counsel. My name is Shayla Lacey, and I represent petitioners Blofeld, King and Carver, and Largo. I will prove to you today that Strafford County violated my client's Fourth Amendment rights to precipitate lengthy and costly modifications to their properties for reasons of personal interest. After 2 children were injured when a shed collapsed, Strafford County maintains they followed proper legal guidelines while investigating further dangers the county posed to its citizens using Google Earth and drones. First, let's talk about the statement that Sheriff Leader gave the public after the tragedy. He said, quote, "When there is an incident, the county has to respond," end quote. Further, the Sheriff's Department believes that Dr. No, quote, "lacked any additional safety requirements that would prevent mishaps or serious injury," end quote. I question these statements. Does the county respond to every incident? If a child falls off the monkey bars and breaks their arm, does the county personally respond to that and require new construction on all county playgrounds? Dr. No's shed was deemed dangerous because it lacked safety requirements, and the county wanted to make sure that wouldn't happen again. Does the county plan on inspecting lawn furniture? Children could walk home from school, jump on a patio table with a loose screw, and become seriously injured. Will the county be inspecting backyard swing sets to make sure that the construction was performed to the manufacturer's safety specifications? This begs the question, why this incident and why now? Sheriff Leader is a new transplant to the county and shoring up for re-election using this incident to appease community members who want to see justice. Strafford County has stated that their actions were permitted by the plain view and open field exceptions under the Fourth Amendment. However, Coolidge v. New Hampshire held that the plain view exception only applies if the initial intrusion is lawful, the discovery of evidence is inadvertent, meaning it was not found through deliberate planning, and the evidence must be immediately identifiable as illegal. Let's start there. The intrusion by drone was in fact unlawful without probable cause. Probable cause requires that a reasonable basis for believing a crime has been committed is present. Seeing a pool or a shed in someone's backyard on a satellite image is not sufficient probable cause to believe a crime has been committed. Next, there was a clear, deliberate planning in the actions taken by the county. First, the appointment of Sergeant Moneypenny by Sheriff Leader to undertake Operation Uncover. Second, the research done on Google Earth. And third, the deployment of the drones to gather evidence. Last, plain view exception does not apply when requiring that the evidence be immediately identifiable as illegal. It is impossible that a satellite or drone image can immediately show whether or not a structure follows county code. I'd like to now address the open field doctrine. In the case of California v. Sorolo, it was determined that police observation from 1,000 feet or above does not violate the Fourth Amendment because there can be no reasonable expectation of privacy in open air at that height. I would agree with this. However, the DJI Mavic Air 2 fly drone comes with an impressive super resolution mode option that offers the digital zoom function using a 12 megapixel sensor and 48 millimeter optical zoom, bringing objects 4 times closer to the eye. While reasonable privacy is not expected at 1,000 feet, I can assure you citizens have a reasonable expectation of privacy at 250 feet. If we look to Katz v. United States, Justice Harlan stated in that case that, quote, "A violation occurs when government officers violate a person's reasonable expectation of privacy," end quote. The county asserts that the open field exception gives them permission to the outdoor space of a home. However, this is false. In Hester v. United States, it is clarified that an open field, quote, "may include any unoccupied or underdeveloped area outside curtilage." Further, in United States v. Dunn, curtilage is defined to be the area immediately around the dwelling and for legal purposes is considered part of the home. Anything outside of that is considered to be an open field. Lastly, in reference to Blofeld in this case, I'll refer to United States v. Jones when the district court granted a motion to partially suppress evidence obtained by law enforcement because the defendant's car being in the garage on his property gave him a reasonable expectation of privacy against search or seizure. With understanding of this precedent, the barn on Blofeld's property is also covered under the Fourth Amendment, and the search and following arrests were illegal. Operation Uncover is not permitted by the plain view nor open field exceptions. Stratford County Sheriff Felix Leader, in direct violation of the Fourth Amendment, capitalized on the opportunity to bring money into the county and grow his reputation. Thank you.